in the name of personal injury law.
We often hear about people asking for damages for personal injuries through civil lawsuits, but we also hear about unfortunate incidents of sexual assault. Today, we are going to discuss the ways in which victims of sexual assault can pursue civil justice and compensation through the court system. We have attorneys Steve Sinas and Jon Homa from the Sinas Law Firm to discuss this important topic with us. Hello, Steve and Jon. Thank you for being here.
Hello.
Thanks for having us.
So, Steve, you regularly talk to us about interesting legal issues regarding matters dealing with personal injury and the civil justice system. Are civil lawsuits regarding sexual assault handled just the same way as any other personal injury case?
Well, one thing I try to stress in this show is that in personal injury matters, the law has different legal rules and issues depending how someone was injured or harmed. There are no universal personal injury rights we all have. And civil lawsuits dealing with sexual assault certainly have their own unique rules and standards. Jon is going to explain the unique area of federal law known as Title IX that applies to sexual assaults in public schools and universities. But before getting there, I just want to say generally that the perpetrator of an assault can be sued in a civil lawsuit. But unless that perpetrator has significant financial assets or wealth, there's not going to be much of a way to recover any financial compensation from that person. And also, insurance policies issued to individuals do not typically cover something like a sexual assault. They consider it an intentional criminal act and there's no coverage. So if you're just suing the person who commits the assault, there may not be any recovery. So you look for other entities or people that could be responsible for the assault.
Okay, so let's talk about that. How can you blame and sue another person or an entity for sexual assault that's committed by somebody else altogether?
So essentially what's happening is that there's a sexual assault that's been committed, and then there's an argument that that person's employer or someone responsible for that person, another entity or the property owner where the assault occurred, it can also be held liable under the theory that they failed to take reasonable efforts to prevent the sexual assault from occurring. It's essentially a negligence standard. But the thing that people have to understand is that if you're going to make that argument and the entity you're dealing with is the government or a governmental entity such as a school system, that there's even a higher standard that applies. This is through governmental immunity principles. And this standard says you have to show gross negligence on behalf of that governmental entity in failing to prevent the sexual assault. That's a much higher standard than negligence. And it's really hard to prove. But what Jon's going to explain is how the federal law known as Title IX provides a recourse to victims of sexual assault in the context of a public school or university and how that area of law works.
Okay, well, Jon, what is Title IX?
Well, Title IX is a federal civil rights law that was passed as part of the Education Amendments Act of 1972. The law prohibits discrimination in schools that receive federal funding assistance, and it's all forms of discrimination. But the courts have also held that sex discrimination includes such acts as sexual assault or sexual harassment. And so it encompasses those situations when there is sexual assault within a school environment.
Can you explain the new Title IX rule?
Yes, well, the new rule was initially published by the Department of Education in May of this year. It became effective on August 14th. It essentially supersedes the existing regulations and the letters of guidance that were issued by the Office of Civil Rights regarding Title IX over the past 25 years. It further provides a framework for not only the grievance process in the school, but also for private causes of action. It's consistent with case law and decisions from the United States Supreme Court that have dealt with Title IX, and really with the private cause of action, it draws striking similarities, but there are also some nuanced differences.
Okay, so what actions would make a school liable for damages under Title IX?
Sure, well, essentially an educational institution will be held liable if an appropriate person within that university received notice that there was some type of inappropriate sexual assault or behavior occurring, and they were deliberately indifferent to that notice. in the context of elementary schools and secondary schools, any employee within the organization would be deemed to be an appropriate person, so that if they receive notice of some type of behavior going on, they would be required to take some type of corrective action. That's different for colleges and universities and post-secondary schools, where an appropriate person that needs to receive the notice would be the actual school board, the Title IX coordinator, or someone else who could actually take corrective action in light of that notice. So essentially, the concept is, if the school receives actual notice that something's happening and they fail to act reasonably in response, then the survivor of the assault can bring an action, a private cause of action against the school for redress of their injuries. So it is an important law for survivors to seek redress for their injuries from schools that have failed to protect them.
So I have a few questions now. So does it matter who the perpetrator is? Does it have to be a school employee, or what if it's a student assaulting another student? Is that Title IX?
Yes. So there are two main avenues of Title IX claims. One area of the law focuses on teacher on student types of assaults. And there is a framework built in for the procedures and the processes that happens when there is some type of teacher on student assault. However, there is a slightly different analysis for when there is student on student sexual assaults. And those assaults could be occurring anywhere within school functions. It could be dormitories, it could be at a school play, or it could be essentially in the classroom. But Title IX covers both of those types of situations. However, there are some nuanced differences in the elements that need to be met and how you would actually present those claims.
Is it harder to prove one kind of case versus another?
Well, every case is different, and it's all based on the amount of evidence that we're able to obtain. Unfortunately, it is still the plaintiff's burden to present evidence that shows that there was not only actual notice, but there was also deliberate indifference to that notice. And witness testimony, proof can be had in various forms of evidence, but witness testimony is one that's very strong that we see time and time again in these claims.
One thing I'll add too is that we're often in a situation where we respond to someone's inquiry about whether they have a case, and we have to tell them that under the technical aspects of the law, they don't have a case, even though they were clearly harmed. And that's one aspect of these laws. There are so many particular standards that apply that some people may have a claim and some people may not. And that's just the reality of the way the law works.
And the reality is that the victim of the assault could bring a case directly against the perpetrator. But what you said earlier, Steve, is that a lot of times those people don't have any money to pay a damage award if there was one. Was that
right? Right. And so they were harmed, but there is no good recourse for them. And that's sometimes the reality that we have to tell people. But we often look for the opportunity to find the special facts and circumstances to make a difference for people.
All right. Thank you, gentlemen.
Thank you.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm.